I'm John Lynch, and I'm going to give you 1 minute on the Wicks Law. You've heard it a lot, but let me explain it for you. The Wicks Law is an older legislation in the state of New York, came in during the 1950s, and requires public entities, such as school districts, to make independent contracts with their, what we call, primes. And that is, the statute specifically calls out plumbing, heating, ventilation, air conditioning, electrical, and general contracting. In a normal sort of project, there's a general contractor who hires a bunch of subs. In a Wicks Law contract, we have each prime contractor hires the prime contractor's own subs. So it's entirely different. The New York State School Boards Association has taken a position against the Wicks Law in arguing that it increases the costs of school district projects by millions of dollars in taxpayers' money each year. There is one exception to it. Upstate, you can do a Wicks Law project when it's very small, but call us and let us review that with you. That's my 1 minute. Now you know what you need to know about Wicks Law.
Hello, my name's James Gregory. This is part of our continuing series on construction works in school districts. I'm going to be talking about, do you need a construction manager or a clerk of the works for your project? So, the entire point of having either one is that the school district is not an expert in construction, and so it does need someone on site on a day-to-day basis to make sure that the work is proceeding according to schedule, and that the contractors are not conflicting with each other and one getting in the way of another. To do that, you hire a construction manager, which is typically an outside firm that specializes in construction management. They tend to be larger, they tend to be highly organized, and they tend to be expensive. Alternately, you can hire a clerk of the works, which has many of the same functions, but these people tend to be in smaller companies or a solo practitioner, and they are more appropriate for smaller projects. What's the size of a project? Typically, it's around $10 million. If your capital project is going to be more than $10 million, you should probably get a construction manager. If it's smaller than $10 million, in our experience, and this is a general rule, you don't need a construction manager. A clerk of the works will suit you better and will save you a significant sum of money. If you have any questions, give us a call. Thank you.
Hello, my name is Daria Gerasimova, and today I will be talking about tie bids. You may be surprised how often owners or municipalities receive identical bids. And in this case, you have the right to elect the contractor, the one that you prefer among those tie bidders. You may also reject all the bids and re-advertise the whole contract. And the crucial point here is that the bids must be absolutely identical, and by that I mean they must be identical to the penny. Thank you.
Hello again. Let's discuss a couple of issues around bidding. First one I want to talk about is mere irregularities versus non-conforming bids. So at the beginning of every bid process, we set out a group of specifications. We want to acquire this product, and this product's got to perform in this fashion. And so bidders often will bid something pretty close, but not exactly what we specified. So what's the difference between a non-conforming bid and an irregular bid? Well, here's a concrete example. Recently, one of our client school districts was redoing their kitchen, and more specifically, the food preparation area of their kitchen. They wanted to replace the worn out furniture in the food prep area. So they specified a bid for all stainless steel prep tables. Why did they specify stainless steel? Because everybody knows stainless steel is antimicrobial, antibacterial, doesn't get cut, cleaner, easier to maintain, all the rest. The low bidder submitted a bid for high impact plastic coated food prep tables. So the question was, is that a mere irregularity or is it a non-conforming bid? After analyzing the literature on stainless steel, which is the reason why the school district spec'd stainless steel, we rejected the bid as non-conforming. Now here's mere irregularity. Another of our school districts specified that the contractor for their brand new swimming pool had to have installed 10 swimming pools in public facilities around the state in the last 10 years. The low bidder came in with an installation of 8 in the last 10 years. After due consideration by the board, it was adjudged a mere irregularity and not a hard and fast requirement. There's some analysis that needs to be done and certainly some consultation with your attorneys. So please give us a call if you think you've got a non-conforming bid.
We're going to be talking about SEQRA, which is the State Environmental Quality Review Act. What is that? That is the law that requires school districts and all other public entities to consider the environmental impact of a project that is pending, and in particular with construction projects. As a school district, what you need to know is that your architect and engineer should be reviewing your project to determine what category it falls in under the Environmental Quality Review Act. There is type 1 projects which have a significant environmental impact. You want to avoid those if at all possible. There are type 2 projects which under the rules are already determined to not have a significant environmental impact. That's where you want to be if you possibly can. And then the third category is unlisted actions, which are everything else. The important thing also to know from a school district's point of view is that your SEQRA determination must be finished prior to going out to the public for a vote to authorize the project, because the courts have said if the project hasn't had its SEQRA review finished, the public can't make a reasonable determination about whether to authorize the project or not. If you have any questions, give us a call. We'll be happy to talk about it more with you, and we're happy to help you draft the resolutions in conjunction with your architects and engineers.
This section, we will be talking about what happens when the contractor makes a bid mistake, and you may be surprised how often this may happen. When the bids are opened and you discover a bid that is substantially lower than the others, it is highly likely that the contractor made a bid mistake. Although the price is the lowest and the deal sounds like a great deal, you may not want to uphold that contractor up to their deal or the bid. So in this case, you want to consult with your architect and make sure that the contractor made a mistake. So when you discover an error, it must be of such nature that enforcement of it would be unconscionable. So, and another point would be a contractor must have submitted the bid in good faith, and there should be some credible evidence establishing that that mistake was unintentional and of clerical nature, such as an arithmetical error, or a contractor just missed a line, or they unintentionally skipped a large quantity of work, labor, or materials in their calculations. And finally, the sole remedy in the case of bid mistakes is withdrawal. Contractor must withdraw from their bid. You cannot modify or reform the terms of the bid. However, you may choose to repeat the contract and reject all the bids in this case. Thank you.
And in this section, we're going to talk a little bit about piggybacking. So what's piggybacking? Piggybacking is when a municipality avoids public bidding by ordering off a contract that has already gone through the public bidding process. Now, for years, you've been able to do that only through the state website and ordering off of state contract. But a few years ago, more than I'd like to admit because I'm getting old, they changed the law, and school districts and other municipalities can now order off of contracts from other public entities from all across the country. The requirements are that it has to be a public entity, and the public entity that did the bidding, they had to have followed rules that basically comply with New York State's municipal public bidding law. That means that they needed to have awarded the contract on the basis of lowest responsible bidder or best value. It means that they needed to have published the bids with some kind of open solicitation, that the bids that they published were not specifically tailored so that only one contractor could win, right? They had to be truly open. And that when the bids are awarded, they're awarded after a closed bid submission to avoid funny business, and that after the bids are opened, there cannot be any post-bid negotiations with losing parties or arm twisting to get people to lower their bids. If you have any questions, give us a call. We have a list of other entities that we have approved as complying with those requirements. Thank you.
Discussion of non-conforming and mere irregularities takes us to the discussion of or equal. You've all heard the phrase, we want to bid such and such a product or equal. What does it really mean? Well, it means simply this. Very often in bid packages, we'll describe what we want by reference to an existing product in the marketplace. So for example, you might say you want a pickup truck similar to a 2022 V8 Ford F-150, and then describe it as a off-the-shelf product available from a Ford dealership. But then you would add or equal. So if the purveyors of a Honda truck or a Plymouth truck or any other truck can compare the specs for their truck to the F-150 we described in our bid package, and we are in agreement that it's or equal, then we can buy that vehicle. But here's you got to be careful, because very often you want to leave it to the judgment of a third party and not the Board of Education or the superintendent to decide if it's equal, because we never want to be accused of favoritism. So it's ordinarily, not with trucks, but with any other physical item that's going into a project, for example, you want to let the architect decide. With vehicles, call your counsel. We'll give you an opinion.